Test. Good morning. We'll call the meeting to order. I believe that we have one member who is participating virtually. Delegate Shin, are you there?
Good morning.
Morning. Okay, we've got some business to take care of before we start hearing the other bills. At the patron's request, House Bill 855, Delegate Reed has requested to strike that bill. That is a voice vote. Do I have a motion to strike? Oh, I'm sorry, that is a recorded vote. Sorry. Do we have a motion to strike? Second. Do we have a second?
Second.
We have a motion, a second. Please vote once it comes up.
Let's just strike. We can't strike the vote yet. I haven't gotten the action up there.
Okay.
Oh, Lord.
Mr. Clerk, I apologize. We do need to take roll.
Okay. Start over then?
Yes, sir.
Okay. You gotta get that out before I close it. Okay. Oh, wow, I get to the screen. All right, now. And Delegate Shen, you still there?
Present.
Okay. Going back to House Bill 855, we did have, we had not taken roll, so do I have a motion to strike the bill? We have a motion to strike. Do we have a second? We have a motion and a second.
All right.
Once it comes up on the screen.
Yeah, since we figured this out, okay. Okay, hold on. And what is the number again? I apologize.
House Bill 855, Delegate Reed.
55. And we're going.
Okay. We also have,
I'm sorry.
go ahead. Please vote.
Everybody's voted out.
All right.
Wait a minute. Delegate Shen?
Aye.
Thank you, Mr. Clerk. Next, at the patron's request, we have two bills. We'll take those up in a block to pass by. House Bill 648, Delegate Corey, and House Bill 448. They requested that those go by for the week. Do I have a motion? That is a voice vote.
Okay, that's voice.
We have a motion and a second. All in favor say aye. 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 All opposed? Okay. Next, we have House Bill 596, Delegate Clark. We're going to request that report and be referred to general laws. Do I have We have a motion and a second, and that is a recorded.
But you don't want any discussion about it before you report it? Okay.
Is there any discussion? Okay.
And
All right, we have a motion and a second.
General laws, right?
Yes, sir.
I'm a little behind you, okay.
That's
we
okay.
got- Okay. Okay. Delegate Shen,
Aye. Excuse me, sorry. Aye.
Okay, thank you, Mr. Clerk. The bill reports and is referred to General Laws 7-0. Okay, now to business. Delegate Marshall, I do believe you've got three bills, House Bill 173, 272, and if I'm not mistaken, there's another bill.
Yeah, 1016. Is that correct, Jeff?
Yeah.
So, good morning, Mr. Chair.
Good morning.
I was on this sub for a number of years, so I'm not going to say how many, but a number. So first of all, I'd like to, House Bill 1016, to strike that bill, please.
Okay, it's a request of the patron. Do we have a motion to strike
that's a recorded vote.
1016? That is a recorded vote. Do we have a motion? We have a motion. Do we have a second? We have a motion and a second. Once it pulls up on the voting screen, please vote.
And Delegate Shen,
Aye.
Thank you, Mr. Clerk. Delegate Marshall, would you prefer to hear 173 or 272 first?
272, if that's okay with the chair.
Yes, sir.
Okay, so House Bill 272 is about land development projects must obtain approval of various plots, plans, and other applications required by local government. Once approved, these plots and plans are considered valid for a specific period of time as prescribed by code. The pandemic, affected these also, has impacted the ability of local and state government agencies to review development applications because many government employees began to work remotely. Land development and construction timelines were delayed in compliance with proper social distances, et cetera. In response, the General Assembly passed legislation during 2020 special session to extend these approvals from July 1, 2020 to July 1, 2022. Well, the pandemic didn't end, so what we before you today is to ask for that extension to go forward. And I would, if the chair is okay, I would ask Andrew Clark with the Home Builders Association to come forward.
Yes, please.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia, and we support the bill. This committee's heard this bill a couple times over the years. As you'll recall, during the 2020 special session, there was legislation to extend the validity till July 1 of this year, and the idea being between shutdowns in local governments and different state agencies and federal partners that review land development plans, just to protect some of the investments and the time that have gone into these projects. COVID really hasn't subsided in the way that we had hoped, and so just granting an additional year for folks to kind of get their house in order before those plans expire. I'll just reiterate the bill from 2020 did address one of the big concerns from local government in that we weren't extending the validity of plans going back to the dawn of time. So plans from 2004, 2005, those are not included in this extension. It goes back to 2015. Plans approved no earlier than 2015. So happy to answer any questions and would be grateful for your support. Thank you.
Chairman Scott McGarry of Washington Gas. We support the bill. I think it's a very reasonable measure that will promote healthy economic development. It also will help utilities to plan, and so we hope it'll be a pleasure to recommend reporting. Thank you.
Mr. Chair, members of the subcommittee, Phil Abraham on behalf of the Virginia Association for Commercial Real Estate. We support this bill. In addition to delays at the local government level, we're also struggling with supply chain delays and labor shortages. This is very important to us. Thank you.
I'm sure nobody's opposed to it.
I do believe we have one person. Well, first let me ask, is there anyone in the room who is opposed to the bill?
Morning, Mr. Chairman. Joe Lurch with Virginia Association of Counties. And just to talk a little bit about how our localities reacted to the pandemic and reviewing plats and plans and also rezonings and special uses, is they were able to go ahead and do two things. One is they have that ability to administratively extend these approvals. I know of one example where Prince William County, their county board actually adopted a resolution giving their planning department that authority, and they made many extensions, but there was a lot that didn't need extensions, and we just feel that it's important for our localities to be able to work with the developers on this. Now, obviously, I think, there's no doubt that there may have been some delays on state and federal permits, but that can be part of that granting that extension at the local level, that recognition, and so we just respectfully ask that these can be worked out at the local level. And just one other point, in some of these larger rezonings and special use permits, they can be, thousands of acres in size. They're very complex, and there's been a commitment to move forward by some of these, developers. And it's getting the local level, that input from citizens and the boards to best move forward. So for that, we oppose the bill. Thank you.
Good morning, Mr. Chair. Eldon James on behalf of the Virginia chapter of the American Planning Association. Much of what Joe Lurch just told you, we've queried our members, and we don't know of any situation where there was an active project, where there was work being done, that the developer or builder didn't ask for more time, that the localities haven't granted it. It's the projects that are dormant and you never hear a thing about that we are concerned about. And when you have situations where there are labor shortages, all the builder developer has to do is ask. Localities and planning departments are looking to promote economic development and growth. It's the stale projects that don't meet current standards that have been updated that no effort has been made to move them forward that we have concern with. Thank you.
So, Mr. Chair, this committee has extended this several times. The wild card here was pandemic, and which may move kind of everything back. So I would ask you to give us an extension.
Yes, sir. If you don't mind, we do have one person who has signed up virtually to speak, Mr. Chip Dix.
Yes, sir, Mr. Chairman and members of the subcommittee, good morning. And I'm here to speak on behalf of Delegate Marshall's bill. And again, as Delegate Marshall explained, this is a COVID-related matter. A couple ideas that are important. If you look at the bill itself, all that's being done is to extend the date, the expiration date. The General Assembly's already adopted the policy of state action as opposed to relying on every locality to make this decision. With all due respect to VACO, the only thing that's being done is extending it from July 1 of 22 to July 1 of 23. The other thing I would point to is on lines 40 through 44. What it does is localities have said, because the old permit extension bill, let's call it that, sunsetted on June 30th of 2020, then their old projects and subdivisions, and Mr. Lurch and Mr. James are exactly correct. There are circumstances where the locality wants those permits to be extended. And yes, there are some stale issues that need to be addressed, and those are best addressed at the local level. And that language on lines 40 through 44 expressly gives localities that authority. So again, we ask you to support the bill. Thank you.
All right, thank you, Mr. Dix. Okay, do we have any comments or questions from the committee members? Yes.
Thank you so much. To the patron, to the question about specific projects that have been held up as a result of the existing timeline running out? I am, as y'all know, very realtor and home buyer, builder friendly, but there is that administrative piece that at the local level, they have the ability to do if there's a line of communication. So are there one or two examples that can be provided of projects that were in the works?
I'm going to phone a friend.
Mr. Chairman, Andrew Clark with the Home Builders. Delegate, I would say there are examples of projects that I think the locality, we're bringing the bill to have a statewide extension, I think partially so applicants don't have to do a case-by-case grant and a request for an extension. When we did the first extension last year, we did actually get members from several localities where there was a lot of hesitation to even extend it under the first extension. So we have seen some pushback for a variety of reasons, and that's why we brought the bill this year to ensure that all the plans are going forward and at least get an additional year to move forward.
Okay, and you said there are examples. I'm taking it you don't have specifics to refer to.
I do, but I would probably prefer not to call out specific localities. But the reason we brought this bill is some of our members felt concerned that they would not get the extension if they went through the administrative process at the local level.
And these are projects that are in motion, not that are dormant.
Yes, ma'am.
Okay.
And again, the extension was limited to plans approved 2015 and beyond. So these aren't, and that was the justification for making that kind of carve out in 2020 special session was somebody who had a plan approved in 2005 probably wasn't held up necessarily by the pandemic.
Okay. So let me ask you this.
Yes, ma'am.
I'm sorry. Let me ask you this quick question. So if someone had plans approved and, or if there was a situation where there was a zoning change and the landholder had, a grandfathered zoning status, and that status expired in the 2020 pandemic or whatever, does this legislation apply to the extension of a grandfathering clause because they were not able to move forward due to the pandemic in 2020, or does that not apply to the grandfathering?
Delegate, I would say without knowing more facts, I couldn't make a statement one way. Maybe I'll phone a friend and bring in Chip Dix, who I know loves talking about that at the chairman's discretion, of course.
Yes, Mr. Dix, are you on the line?
I am, sir.
I do believe Delegate.
Can you hear me, sir?
Yes, sir. Please go ahead.
Okay. So, Delegate, the answer would be that anything that was grandfathered, I think you mentioned 2010,
Yes.
anything that goes back that far was sunsetted on June 30th of 2020.
Right.
And so none of those old projects apply. One of the things, if you look at lines 40 through 44, a couple of localities, Mr. Clark and I were aware of circumstances, and I've been a zoning lawyer for 40 years in addition to lobbying, so I actually live this stuff.
Mm-hmm.
So in addition to the locality saying, what happens if there was a project prior to 2020 and all those projects sunsetted, unless they had a pending site plan, as Mr. Clark said, it could go back as long as 5 years, so 2015, 2016 timeframe. Most of those were roaring projects, and quite frankly, things were moving forward with no problem because we didn't have the COVID pandemic until 2020. So that's when everything started coming to a screeching halt. And those timeframes that would have needed to be completed 20 or 21 were not able to be completed. And that's the purpose of this bill. And again, not to have developers go case by case by case with 154 localities in the Commonwealth. So we thought a statewide approach was appropriate. but anything under lines 40 through 44 that the locality wanted to extend that was in that grandfather period that you're talking about, then a locality and a developer could establish conditions and revalidate that project on whatever appropriate conditions were necessary. It might be zoning, might be conditional use, it might be an amendment of site plan to update to meet stormwater, any of the things that would need to bring things up to current code standard, if you would. So I hope that answers your question, but I'm happy to answer another one if you have it.
Okay, it does. Thank you. Thank you, Mr. Chair.
Thank you very much. And the realtors and the development community, we didn't go through the list, but there's chambers and realtors and development community and housing alliance and Northern Virginia Apartment Association, a bunch of different groups and organizations and companies support this bill. Thank you, Mr. Chairman.
Okay, thank you. Any other questions or comments from the committee?
Mr. Chairman, I move to report HB 272.
We have a motion to report. Do we have a second? We have a motion to report, second. Please vote.
Delegate Shen,
No.
Okay, Delegate Marshall, the bill reports 5-2.
Thank you,
All right, thank you. And next we have House Bill 173.
We do, and I think Mr. Sharp has a amendment to the original bill, which is on line 22. It strikes the word qualified voters and then adds the voting on the question. And so I'd like to offer that amendment, please.
We have an amendment before us. Do we have a motion? We have a motion. Do we have a second?
Second.
All right. All in favor, say aye.
Aye.
Aye. All opposed? All right.
So simple bill, and I've got several people here that would like to speak to this bill, and I think you got a couple in the queue that would like to speak to it also. And what this bill does, it's simple transparency. This is a big question for Martinsville to revert from a city to a town, and a question this large to me should go before the voters. Just a couple of years ago in Danville, Pennsylvania, and Henry, surrounding us, there was a question about 1% sales tax. That was not decided by a city council. It was not decided by a board of supervisors. The citizens decided. So in a situation like this, we think that the voters the number of people who are voting, the majority of those who are voting should be able to decide if the city should revert to a town. So I have people here that would like to speak to the bill at your convenience.
Okay, thank you, Delegate Marshall. I know we've got several people here today willing to speak in favor and some against. We also have several that have signed up virtually. And so first we'll hear those in support of the bill who are here in person. And if you represent, if there are several of you that, for example, represent Henry County or the city of Martinsville, what I would like to do is limit that to 3 representatives from each, whether for or against the legislation. And please keep that testimony at 1 minute.
Good morning, Chairman Moorfield and members of the subcommittee. I'm Ruth Easley. I'm the duly elected Commissioner of Revenue in the city of Martinsville. I'm not speaking to you today because this legislation affects me personally as a constitutional officer. I am speaking to you on behalf of residents of the city of Martinsville who have expressed to me that they feel like they have not been afforded a voice in this process or full public vetting of the consequences of the current reversion action. I've been the Commissioner of Revenue since 2002. During my tenure, the topic of reversion has been brought up 3 times. The previous councils that brought it up, there was more citizen input involved and stakeholder input but the previous councils decided not to pursue the issue of reversion. In 2006, Martinsville City Council unanimously approved a resolution stating, quote, that the issue of reversion of the city to a town should be submitted to the voters of Martinsville, yet they failed to seek enabling legislation to do that. Since 2006, Martinsville City Council has repeatedly opposed legislative attempts to allow local residents a voice through referendum and a reversion process. On Tuesday evening, Martinsville City Council added a last-minute ordinance to their agenda without public notice to petition the circuit court to move forward with the reversion process. The ordinance was adopted 4-1 on first reading with no public hearing. The second reading will occur tonight in a special called meeting at 6:30. I don't think this demonstrates a willingness of Martinsville City Council to engage their stakeholders. To paraphrase Abraham Lincoln, what we want to get done is what the people desire to have done, and the question for us is how to find that exactly. The answer for Martinsville residents is a yes vote on Delegate Marshall's bill before you today, allowing the Martinsville residents the opportunity to speak best through the ballot. If, as a majority of council members have asserted, most of the city residents are in favor of a reversion, that assumption will be upheld by the voters voting in a city referendum. Thank you.
Thank you, ma'am. Do we have two other?
Councilwoman Pearson is also online this morning in favor, and I believe Lawrence Mitchell is also in favor of this legislation.
Yes, ma'am. So as I mentioned earlier, we're going to limit comment from Martinsville to two other individuals. And so please try to limit your comments to 1 minute. I'm sorry, Councilwoman Pearson, please go ahead.
Good morning, Chairman Morfield. I am Tammy Pearson, an elected member of the Martinsville City Council. Along with my husband, we also own several small businesses in Martinsville and Henry County. I was not a council member when they initially voted to move forward. However, once elected, I was the only dissenting vote against the agreement. I voted no primarily due to the city's process, its lack of transparency, and failure to not only seek input from a broad base of our citizens, but also from SMEs in regards to our school system, taxes, businesses, and more. This negatively impacts the unified partnership Martinsville and Henry County must have in order to attract prospective businesses and a younger diversified demographic to our struggling area. Finally, please ask yourself not why should I vote to move this bill forward, but why not? It is not too late. Why not vote for a bill allowing a majority of our citizens voting in a city referendum to speak loud and clear in a transparent, fearless manner about the future of their own community? As you know from your own experiences, we must not only hear, but truly listen to our citizens. And I firmly believe a city referendum is the only way to do so. Thank you for truly listening.
Thank you, Councilwoman. Okay, we will take
Mr. Mitchell.
Mr. Mitchell, please.
Can you hear me?
Yes, sir. And please limit your comments to 1 minute.
Yes, my name is Lawrence Mitchell. I'm a local resident of Martinsville, Virginia. I'm also a former school board member. I think that this bill should go to vote by the citizens of Martinsville, not only just for the residents, but for the kids of Martinsville. Our school board and our schools are very important, and I think that the citizens of Martinsville should have a say in how this goes about. Thank you very much.
Okay, thank you.
And Mr. Chair, briefly, if I could ask, Tim Hall just popped up. He is the county manager of Henry County. If he could take a minute.
Yes, sir. Go ahead, Mr. Hall.
Good morning, Chairman Moorfield and members of the committee. I'll be quick. I'm representing Henry County Board of Supervisors. The board asks that you vote in favor of HB 173 and moving on. We really think this is a simple question. The city residents deserve a say in their future. There are approximately 14,000 residents of the city of Martinsville. And as things sit now, city council's 5 members can vote to make a generational change. And once a city reverts to a town, there is no going back. So the county is in favor of HB 173. And We would like for the committee to move it on and allow the citizens to have a say in their future. Thank you for your time.
Okay, thank you, sir. Since we already have representatives from Martinsville speaking, we do have one person signed up to speak from Martinsville against the bill. Mr. Mende.
It's Monday.
Monday?
Yeah.
It's City Attorney.
Eric Monday, Mr. Chairman. Are you able to hear me?
Yes, sir.
Thank you, Mr. Chairman. Eric Monday, I'm the city attorney for Martinsville. Reversion has been discussed in Martinsville for about 40 years, which is about the same amount of time that the current structure for reversion has been in place without a referendum requirement for a city of our size. We hope that you will leave the statutory structure in place as we are currently engaged in litigation that's already been started with Henry County. And the suggestion that there has not been transparency or an opportunity for citizen input is simply inaccurate. Since this process was begun in 2019, there have been 4 dedicated public hearings on the issue of reversion, one of which was conducted by the Commission on Local Government in accordance with the current code requirements. There have been 12 public information sessions specifically dedicated to reversion, all of which have the opportunity for public comment. There have been 4 neighborhood meetings conducted by the City Council, also with the opportunity for public comment. There have been over 70 public comment opportunities at City Council meetings. And I should add that at all of these, there was practically no opinion voiced one way or the other on the issue of reversion. There's also been a dedicated email site solely for comments on reversion set up since 2019. We have received 4 emails, one of which was from a county resident on the issue. So there has been ample opportunity for public comment. And we certainly hope that you will not change the rules governing reversion in the 4th quarter of the game. We are, as I say, currently engaged in litigation, and we believe the statute should remain as it is.
All right.
Thank you, Mr.
Thank you, Mr. Monday. Okay, now we're going to go back to in-person testimony. Is there anyone here in the room to speak against the bill?
Good morning, Mr. Chairman, members of the committee. My name is Stephen Peepgrass.
Yes, sir. Good morning. And please, I hate to remind everyone over and over, but we are trying to be respectful of everyone's time. Please limit your comments to 1 minute.
I understand.
Thank you.
Thank you. I'm with the law firm of Troutman Pepper, Hamilton Sanders, and represent the city in its reversion proceedings. And I just want to very briefly highlight the one issue Mr. Monday referenced, which is changing the rules in the middle of the game. We became involved in this particular effort at reversion for Martinsville in 2018 and began having studies done, education, financial studies, feasibility studies, all under the 40-year-old framework for reversion that had been in place and that everyone has been operating under. We filed for reversion with the Commission on Local Government 2 years ago, and this has been going on since 2020. And here we are, we'd gotten to the 1-yard line with reversion. We had a settlement agreement in place, and then at the very last minute, Henry County reneged, thinking it could come to this body and change those rules at the very end of the game to favor Henry County. To do so is bad politics, it creates bad precedent, it's bad public policy, it's bad for the people of Virginia. And the Commission on Local Government, as Mr. Monday referenced, has already weighed in on this after a full-blown hearings and a great deal of public comment, found that it was in the best interests of both the city and the county and the public. And all of the parties agreed, and now we're here having the rules changed. That shouldn't happen. It's bad for Virginia, and we oppose the bill. Thank you.
All right, thank you, sir. Yes.
I just have a quick question with regard to the gentleman who's, not the last gentleman who spoke, but the other gentleman who gave the rundown of public comment.
Yes, Delegate, if you don't mind, we'll take questions from the committee after the testimony. If that's okay. All right.
Thank you.
Thank you. Yes, ma'am.
Hi, Michelle Gowdy with the Virginia Municipal League. We
Yes,
just
ma'am.
want to say that the Commission on Local Government really did hear this case and made a finding, and we think we should support that finding. So for that reason, we oppose the bill.
Okay, thank you. Do we have anyone in the room to speak against the bill? I believe we've heard all the testimony from individuals who have signed up virtually to speak, so we'll now take questions and comments from the committee. Thank you, Delegate.
Thank you, Mr. Chair. The gentleman who spoke from the county, I believe it was, who outlined the number of public hearings and outreach meetings.
Yeah, that was Tim Hall.
Okay.
The county manager.
Okay, great, thank you. Over what time period? Was that over 5 years, 1 year? Over what time period did that happen?
Actually, it was not me. It was actually Mr. Mundy with the city who was outlining those numbers. So you may want to refer that question to him.
All right, Eric Mundy, who is the city attorney of Martinsville.
Yes, sir. Mr. Monday, can you please answer the question?
Yes, thank you, Mr. Chairman. Delegate, that time period started in 2019, but the bulk of those have occurred since 2020. I believe 2 of those public hearings occurred during 2019. The other 2 have been subsequent to that. We filed the petition in August of 2020, and by far the bulk of the numbers that I reviewed for the committee have occurred since August of 2020.
Okay, thank you.
Mr. Chairman,
Yes, Delegate Shin.
may I speak to the bill?
Can you hold just one moment?
Sure.
I believe the delegate had a follow-up question.
I did have a follow-up question.
Sorry,
I'm just
Delegate
not
Grace.
sure who
Yes, ma'am.
it's for, but what is the benefit of reversion?
Mr. Chairman, I'd be happy to speak to that if you wish.
Yes, sir.
Thank you, Mr. Chairman. Delegate, the benefits to reversion, well, there are a number of them. The constitutional offices, when we become a town, the constitutional offices, including the Commissioner of the Revenue, who was Ms. Easley that spoke to you first, are abolished. Our court system is folded into the county court system, so there is a single. So the county constitutional officers would be the constitutional officers for Martinsville and Henry County. Our court system would be folded into the county court system, so there would be a single unified court system. And also the city school system, which we have experienced increasing budget requests over the last quarter century, coupled with a declining school population. We now have a total school population of around 1,800 and a budget of around 18 million, if memory serves me on that. That would cease to exist and become part of the county school system. So it is a streamlining of many of the governmental functions. The town would continue to operate its own police, fire, and utility systems, but we would be subordinate to Henry County, and as I said, the constitutional court and school functions would be folded into the county. We also keep all of our debt. That is something that has been consistently misrepresented through the reversion process. People are under the impression that this is a scheme for Martinsville to push all of its debt off onto the county, and that's simply not true. It's not allowed under current state law governing reversion.
And what would happen to your position?
My position continues. I would be the town attorney, but obviously I would not have anything to do with the school system or the fire or the police departments. Well, I'm sorry, I would continue to represent the fire police departments, but I would not be involved with the school system or the constitutional functions. Those would go to the county.
Thank you, Mr. Chair. Thank you.
Okay, thank you. And Delegate Shin, I apologize, but Delegate LaRock requested about 10 minutes ago to ask a question. So I'll take you next if that's okay.
Thank you, Mr. Chairman. Question for the patron. Any situation such as this which appears to, there appears to be disagreement as to whether or not the voters, the citizens of Martinsville would have the final say in such a huge decision. I can't help but think I'm missing something. So since you can't figure out everything I may have missed, I'll just try to ask a couple questions, or a question. The dynamic in play here, I think, is that the board, town council,
city council advertised an action. I think one of the first speakers said without public notice. So is public notice required? Was that circumvented? Any legal
requirement circumvented
So
there?
Doug LaRock, I'm going to ask Ruth Easley, who lives in Martinsville, to maybe answer those specific questions because she's living and breathing this for the last few years.
Okay, and if,
okay.
as a general follow-up, if you could just briefly explain the position of the council, who I guess is, if we would say, in opposition to this bill, the majority, with the exception of the one person that spoke, and if you have a sense for why they've taken that position. If it hasn't, anything, I generally understand the testimony that's taken place so far, but are there any other positions that they have stated other than what has been brought forward? I guess I'm asking you to make your opponent's case here, but at any rate,
why they want to move forward with reversion?
I can't help but think I'm missing something here, but that's too broad a question.
As residents, so are we. I mean, quite frankly, we get reports. There have been consultant studies that were presented. They were presented the night of that the city council pulled the trigger on reversion. The study was actually posted on the city's website the day after the vote was taken, so no one had an opportunity to review the information that was in there. There have been presentations, but the problem is it is such a complex issue that it's difficult to follow.
Was there a legal requirement, just to repeat my question?
Oh, the legal requirements?
That it be posted in advance?
I can't answer that question. I mean, all I can say is you may have a right to do something, but just because you have the right to do it doesn't necessarily make it right. Okay, thank you.
All right, thank you, Delegate Rock. Delegate Shin?
Mr. Chair, may I first ask a question to the patron?
Yes, ma'am.
I would ask the patron when the last city council election of Martinsville was, and if they could also answer for me how long those terms are for city council members.
It's a 4-year term and for city council, and the last term election was in 2021.
In 2021. So
five members of council.
Thank you, Mr. Patron. Well, thank you, Delegate. And Mr. Chair, if I could speak to the bill now.
Yes, ma'am. Go ahead.
Based on a brief Google search, I can see that this reversion process has been in the works since 2006. It seems like this has come back and forth before the General Assembly a couple of times in the past as well. And I would just say that my concern would be that I believe each city council member is duly elected and entrusted with the votes and voices of the people that they represent. And I would be concerned that we are overruling what seems to be a recently elected body and their votes and their voices for the folks the constituents that they represent. So I just wanted to say that. Thank you.
Okay, thank you. Okay, do we have any other questions or comments from the committee members? Yes, sir. Go ahead, Delegate Mullen.
Thank you, Mr. Chair. I just had a brief question for the attorney from Troutman. Is the attorney from Troutman still here? Good morning,
Yes,
sir.
Good morning.
If you might just give me a brief overview of the current state of the legal proceedings regarding this.
Certainly. So the Commission on Local Government Proceeding was filed back in September of 2020. There was an arbitration that was filed with the McCammon Group under the voluntary settlement agreement that the parties had reached. Then the county filed its own action trying to stay arbitration. That is currently pending in Henry County Circuit Court. Then the ordinance, which was just passed, shifts this back onto the, passed in the city, shifts this back onto the contested reversion track. As part of that, we are filing today a motion in Henry County Circuit Court asking for all of this to be sent to a special court to be appointed by the Supreme Court of Virginia, which the code said is the correct judicial body to decide disputes related to reversion. So that's where it currently stands, and that process traces back to the September 2020 filing by the city.
Okay, go ahead.
Thank you, Mr. Chair. Thank you,
Thank
sir. If I might briefly just speak to the bill.
Yes, please go ahead.
Thank you, Mr. Chair. Mr. Chair, my only concern with this beyond the substance of it, was that I was and remain concerned that there's ongoing litigation, and that as a general situation, we don't usually intervene in those cases in which there's ongoing contested litigation. But I certainly understand where everyone is coming with this. It seems like a very fraught issue. Thank you, sir.
And, Ms. Chair, if I could answer that question.
Yes, sir. Go ahead.
I think it was planned that way so that that question could be brought up. This whole reversion process has kind of been hot, been cold. The city has wanted to do it, then they pulled back and whatnot. So to me, the city attorney talked about public comment. The best public comment would be November of this year, is to let it go before the voters. So all of us trust the voters every 2 years. I think Martinsville should trust its voters also. This is a major question for the voters of Martinsville, the citizens of Martinsville. So I think the voters should have the last word.
Thank you, Delegate. I believe we have one more question.
Just speaking to the bill.
Go ahead, please.
I tend to agree with you in this case. The thing that strikes me about the reversion is that it is forever, and that it's a situation that can't be undone once it's done. And so what gives me heartburn about that are the future generations of folks who will come behind. I mean, this affects their tax base, it affects their education system, it affects so much of the everyday lives of the residents of Martinsville that they should have the opportunity to have a say. We know that there are people in our communities who tune in to elections, and they may not tune into anything else because they come and they do their civic duty and they elect us to represent them, and we are in a representative form of government. But I think this is an important issue that just, it's just basic kitchen table stuff that affects people, and they may or may not realize how it will affect them for the rest of their lives and their children's. But it's a big deal.
Thank you. Would you like to be a co-patron?
Mr. Chairman, I'd like to make a motion at the appropriate time.
Thank you. I believe that is the time.
I move to report the bill to the full committee.
All right. We have a motion with an amendment to report.
We're voting on the referendum.
The substitute that we adopted. Yes, that's correct. So we have a motion to adopt with the amendment. Do we have a second? Second. Okay. All in favor, say aye. Or vote. Yes. And members of the committee, sometimes if you have if you have an issue with your voting screen, just hit the refresh button. Sometimes that works.
Call for Shin.
Okay, Delegate Shin.
I'm a no.
Okay. Thank you, Delegate Marshall. The bill reports 6-3.
And thank you for your time.
Thank you. Okay, we will now take a 30-minute recess. I'm just kidding. I wish I had a picture of everyone's face when I said that. All right, Delegate Leftwich.
All right, thank you, Mr. Chair, members of the committee. I'm sorry I didn't advise the legislative services of this in advance, but it's a pretty simple amendment, because I'm just going to simply ask that you strike the language from line 215 to 225 from the bill, which essentially deals with agricultural subdivisions. Meaning we'll only be dealing with lines 78 and 83.
Okay, thank you, Delegate. Mr. Sharp, could you repeat that, please?
Mr. Chairman, the bill currently consists of two sections. As I understand, we're going to remove that second section entirely from the bill.
Yes, sir.
Since we're no longer going to have that amendment. So the bill will now consist of what you see, beginning on line 1 through line 102.
All right, we have a motion to accept the amendment. Do I have a second? We have a second. All in favor, say aye. Aye. All opposed? Okay.
Okay,
Yes,
thank you,
sir.
Mr. Chairman. So really what we're dealing with is lines 78 through 83. There are two things that those lines would do. I'll handle them separately. One is dealing with boundary line agreements. And so this issue came to my attention when a locality indicated that any change in a boundary line would require a subdivision plat, which involves, if not thousands, not tens of thousands, thousands of dollars. And so the problem with that interpretation of the code was that if you have an older legal description that says starting at a granite rock on the east side of Route 10, thence running 110 feet to a bend in the creek, thence running this direction to an old oak tree, and so forth and so on. And now the granite rock is gone, the creek is gone, or changed direction, and the tree is gone. And two landowners want to enter into an agreement as to where their boundary line actually exists with a survey. You can't do that. You have to go out and hire an engineer and get this 100-acre parcel surveyed, this 100-acre parcel surveyed, submit a subdivision plan, and then have the city approve it. And after about a year, in some jurisdictions, you then have a solid boundary line, which would allow you to sell the property and get title insurance. So that's the first issue. The second issue deals with partition suits. And this issue, in my mind, involves the interplay of three things. One is property rights. Two is well-established property law, which might get into the court's jurisdiction. And then it deals with the ability of localities to govern subdivisions. I dealt with this several years ago in the courts committee, where we completely and utterly revamped the partition process. And the reason we did that was because properties subject to partition suits were being used to essentially cheat heirs out of the value of their property. And so I remember I've been doing property law for now over 30 years, and one of the first cases I handled, I remember this woman very clearly. Her name was Josephine Robertson, and she had worked a menial job her whole life, had a piece of property. A developer wanted to buy it, and I started the partition suit. And when you started evaluating the ownership, there was one person who had 1/242 interest in the property. And being able to partition this property was the only way that this woman would experience any value out of the property. And so what has typically occurred in my experiences is that if you have a lawsuit and a court hears a partition suit and then divides the property, then that property would be exempt from minimum lot area, lot width, square footage. So, for example, and this is, you could have different types of examples, but in an extreme example, you could have a piece of property located in an R15 zoning district, which means building lots have to be 15,000 square feet, and you have two owners, and they want to divide it, and each one winds up with 14,999 square feet. You could not build a house on it, okay? Present example, that's one of the first examples that I have. Second example would be a gentleman who family-owned property, and it's in a historically minority district of my city. And this young man has been wildly successful beyond anyone's imagination. And he went back and he wants to buy the property that the family sharecropped many, many years ago and divide it. But he can't do that through the normal subdivision process. So he wants to buy it through a partition suit, pay for fair value for it, and then use that as a way to allow family members who've been displaced over the years to come back and live on this property that's been in his family for generations, if not 100 years. And so This is not a way to get around the subdivision ordinance, to get around the plat process for big developments. It's a way for landowners who own property and want to divide it through partition in kind are allowed to do that, experience value out of it, and not be subjected to, in some cases, tens of thousands. And I've handled some matters where people are spending over $100,000 in off-site improvements, stop lights, road widths, ditch improvements, and all kinds of things. So I would ask the committee to look favorably upon this bill.
Okay. Do we have anyone here in person to speak in favor of the bill? And I apologize, I have a mint in my mouth. Okay. We do have anyone in person to speak against the bill?
Morning, Mr. Chairman. Joe Lurch with VACO, and thank the delegate for the explanation for what he's trying to achieve, and just had briefly a chance to talk to him before committee. Do have some concerns with some of the implications that we're trying to get feedback from our members on, particularly on line 80, dealing with the boundary line agreement, or what more commonly might be known as a boundary line adjustment. This is kind of opening up the door where you could have these things be adjusted, and then you end up with lots that may have issues regarding, septic systems, having available land for that, RPAs in the Bay Act localities. There could be some issues that it's good for the county to understand what those boundary line adjustments would result in, and that's the reason why this ends up kind of in the subdivision. If there's a way that we could talk to the patron to maybe try to address the issues trying to get to, I mean, we'd love to have that conversation. But just going forward, we have reservations with the bill as written. And as I said, we're going to continue to get comments from our members about that. So thank you.
Okay, thank you. I do believe we have one person. Oh, I'm sorry. Go ahead. Yes, ma'am.
Michelle Gaddy from VML. The only thing I'll add is that there may be issues with resale as well. And so I think we need to keep in mind that while the first boundary line adjustment may be okay, when you go to sell it, you may be subject to the local zoning code, which may change that ability to sell the lot. So thank you.
Okay, thank you. We do have one person who has signed up virtually to speak, Mr. Chip Dix.
Yes, sir, Mr. Chairman. Can you hear me?
Yes, sir.
So represent the Virginia Association of Realtors on this matter, and on lines 79 and 80, having done boundary line adjustments in my real estate practice over the years, we talk about a valid and enforceable boundary line adjustment. So effectively, when I've done boundary line adjustments, you go to the planning director or to the zoning administrator and you get their approval for a boundary line adjustment, and you get their determination that your property, once the boundary line adjustment is valid and enforceable and in place, would obviate the necessity of doing a subdivision. And so that, I think, is the intention of that language. And if there's clarifying language that they could, when VML think is necessary, then happy to participate in helping to arrive on that language. But I think the intention of Delegate Leftwich is to, if you go through the zoning administrator process and you get approval to do a boundary line adjustment, if you do a boundary line adjustment and you record that with your deed plat, then under that circumstance, that ought to be recognized by the locality. And it's insurable from a title insurance perspective as well. So we'd urge you to support the bill. And again, we can work on language as that's needed. Thank you very much.
Thank you. I believe that's all the testimony we have from the public comments. Do we have any questions or comments from the committee? Yes, Delegate, go ahead. And I apologize if it's not working on my screen, so if you make a request to speak, just yell at me.
Thank you, Mr. Chairman. I have a question for the patron.
Yes.
Does the bill also take precedence over setback requirements for structures, for example, driveways or gazebos?
So if the partition suit occurred and a court heard the case and entered an order, and there was an existing driveway, then yes, that would essentially be exempt from the setbacks that were in the zoning ordinance.
Okay. Thank you, Mr. Chairman.
Okay. Delegate LaRock.
I have a couple of questions, if I may, rapid fire. Thank you. Question for the patron. Would this affect the goals of a comprehensive plan potentially?
Well, so comp plans are guidance, and the city council, at least from my interaction with our city council, is not required to comply with the comp plan in every zoning or variance request. And really, I don't think this would fall under a comp plan so much because it's on a small scale. I mean, you're not going to see a 20-lot subdivision come in by a developer through a partition suit. This is designed, really the partition suits are generally going to involve maybe 2 or 3 siblings or heirs that didn't really know they were related. And so and typically something like this would be handled through, if you had what we call a non-conforming piece of property, it would be handled through the variance process. And what this would do is would say if you have 2 pieces, you have a simple example, 3 siblings own a piece of property, they inherit 1.5 acres, and for some reason the property has meaning and they want to divide it in kind instead of selling it. They could divide it and each one could have a 1/2 acre lot. If you're in an area that requires 1 acre, well then you'd be exempt from that 1 acre requirement. You couldn't put a house on 2,000 square feet. It's just not enough room. So it's not one of those situations where you could go to you partition it and then end up with a result that's ridiculous.
Thank you.
There's a little bit of grace for landowners.
Yeah. Additional question, if I may?
Yes, go ahead.
So my concern is that whenever we preempt local authority, that it only be done with extreme caution. And so would this potentially affect, say, the lot size that might be close to a minimum so as to make a property developable that might not be developable?
So when you say developable, that's a very broad concept. Are we talking about a PUD or a 100-lot subdivision? Are we talking about condos, townhouses? So in essence, what you would wind up with is the overarching zoning district would govern. So my example, you had 3 owners, 1.5 acres, and you wanted to cut that up so that each person could own a 1/2 acre. You're not going to be able to put townhouses because the only thing that's allowed in there is single-family residences. So you may have one residence where the zoning would suggest that the size of the lot may be affected, but the type of unit or the type of activity on the property would not be changed by this bill. The use would have to stay the same, but it could allow someone who winds up with a 10,000 square foot lot to build something in an area that would only otherwise require 15,000 square foot lots. So you could now that supposes that you can fit that house on that footprint, that if there's not public water or sewer, that you have room to put a well in, and it would not obviate the need for the well to be 100 feet away from the house, and that you still have to comply with RPA setbacks. So all it does is say, and let's say, for example, from where I'm from, if you're out in the agricultural area, they want to see at least 100 foot of width for an agricultural lot. If you had a pipe stem property with a 50-foot entrance, and the pipe was in the back, and you had room, 10 acres back there, then that would, allow you to do that, even though typically you'd have to have 100 feet of road frontage. You only have 50, but you still have room in the back to put a house. And so it's not one of those situations where you're going to have a large-scale subdivision go in. It's going to be an isolated occurrence where you have multiple owners of a piece of property who, for whatever reason, don't want to sell it but want to live on it. And if it happens to be in an industrial area, perhaps they could put some type of industrial use, but it's not going to change the type of use that you put on there. I hope that's responsive. Kind of feel like I rambled a little bit.
Okay. Do we have any questions or comments from the committee? Chairman Leftwich, I do have a question. How would this apply to tiny homes?
I'm sorry?
Tiny homes? No, I'm just kidding. Okay. No further questions or comments, but we do have one.
Mr. Chairman, I have a question for the patron.
Go ahead.
Thank you, Mr. Chairman. Just for clarity, I just have concerns about the impact that this could have on the character of a development. So for clarity, if going back to my initial question about gazebos and driveways, for example, if there are two lots with the boundary line adjustments, and if they have existing structures, do those structures need to be moved?
So, so there are two aspects of the bill. One is the partition suits, which is totally distinct and separate from the boundary line. And your question relates to the boundary lines. And so, to answer your question directly, yes, you would have to move the structure, but nobody in their right mind would enter into a boundary line agreement that required them to move their house. And so the example I gave you is one example where you have large tracts of land. The legal descriptions are so old and that the markers no longer exist. For example, I just got finished with a partition suit that was near the Dismal Swamp, and over the course of time, the markers for the canal that George Washington dug with help, obviously, have fallen into the canal. So the legal descriptions start at marker 5 on the eastern side of the Dismal Swamp Canal, then it's running. You can't find the marker. And so people need a way to determine where the property starts. And you can't always do that, so they need a boundary line agreement to demarcate where that begins. And the real reason this came to my attention was I had a family that wanted to use a boundary line agreement to resolve an issue, and I contacted the city attorney, and I said, look, I've got a title insurance company that will insure this, but I want to make sure that, I'm playing ball, right. And no new lots created, no easements affected, and there's no new road frontage. Okay, we just need to solve this boundary line agreement. Will you sign off on it? Will you approve this? No. You got to file a subdivision plat to do it. Well, my clients don't have the money to pay an engineer $5,000 and $10,000 to do this. We're not changing anything significant here. And I gave my example to the city attorney about the granite rock and the creek and the tree, and their response was, well, that involves discretion. I said, well, wait a minute, no. You don't get to pick and choose who gets to do this. Either the law allows it or it doesn't allow it. If you happen to like the person who wants to do it and you allow it, that's discretion. But if you don't like the person who wants to do it, that's an abuse of discretion. Either it's permitted or it's not permitted. And my folks are playing by the rules. No new lot, no new road frontage. It doesn't affect an easement. It was trying to fix a confusion as to where that property begins and ends. It doesn't affect. You're not going to see this in a like a big subdivision where you have 50,000 square foot lots, unless perhaps you have a situation where, you know, I've had cases where you've got a subdivision that comes right up next to an older home that's been there for 50 or 60 years. And that person goes out and replaces their HVAC unit on the side of their house, okay? And then they want to go sell, and they realize the setbacks aren't sufficient between the HVAC unit and their neighbor. And so maybe you want to do a boundary line adjustment of like a couple feet so you have the proper setbacks, so you can sell it and get title insurance. You know, that's what this is designed to address. No one's trying to circumvent the subdivision ordinance and create lots or things that you couldn't otherwise do through the proper process.
Mr. Chairman.
Okay, I believe, thank you, Delegate. We have a motion.
I'm ready to make the motion at the appropriate time.
That is now.
I move to report.
Okay, we have a motion to report. Do we have a second?
We have
As amended?
Substitute motion, please.
We have a motion to report as amended. Do we have we have a second?
No, we have a substitute motion.
Yes.
Okay.
Yes.
The substitute motion would be to, and I hope I'm saying this right, gently lay it on the table and refer it to housing for a study. I understand the intent, but I also want to make sure that there are no negative consequences that may be unintended consequences of this bill. So can we refer it to housing for study and then bring it back?
Okay, we have a motion. Yeah,
Yes.
that was that. We have a substitute motion. Go ahead.
We have a second?
Second. We have a substitute motion with a second.
If I could ask just a point of clarification, the substitute motion is refer it to housing and then bring it back to this committee?
If that, I believe I'm saying that correctly, it would be to gently lay it on the table with the recommendation or request to submit to housing for a study.
If I could speak to that.
Go ahead, Delegate.
So I appreciate Delegate Williams-Graves trying to help, but I would respectfully object to that motion. I don't think housing would be the proper place to send this. It's really more an issue of property law and property rights, and so.
Okay, we have a motion. We have a substitute motion. Do we have a second? We have a substitute motion. Substitute motion and a second. Please vote.
Delegate Shen,
Aye.
Okay, the motion fails. 5-3.
Mr. Chairman.
Yes, Delegate.
I go back to my original motion to report the bill.
We have a motion to report. Do we have a second? All right, it's been seconded. Okay, please vote.
okay, hold on, let me get it up there. 1088, I've lost it.
Mr. Chairman, I correct that, the motion to report as amended.
Motion to report as amended. We do have a second. So please vote.
Delegate Shen,
No.
Okay, the bill passes. It's reported 4-3. Thank you, Delegate.
Thank you. Thanks, Mr. Chairman.
Okay, members of the committee, I just became aware that there are a couple of members that have transportation in a few minutes, so we're going to go into recess for 2 minutes.
Mr. Chairman.
Okay, just one second, Delegate LaRock. Okay, thank you. The meeting, call the meeting back to order. We did have a technical issue on Delegate Leftwich's bill. The motion failed 4-4, but I do believe we have a motion.
Mr. Chairman, having voted on the prevailing side, I would ask that we reconsider that vote.
Second.
We have a motion to reconsider in a second. All in favor say aye.
Aye.
Aye. All opposed?
Mr. Chairman, I would move that we pass that bill by for the day.
Okay, we have a motion to pass the bill by for the day. Do we have a second?
Second.
We have a second. All in favor say aye.
Aye.
Aye. All opposed? Okay, thank you. And Delegate Shin, please vote. You're voting on the motion to pass the bill, a voice vote, to pass by for the day.
Yep, I agree to vote to pass by for the day.
Okay, thank you. Okay, next on the agenda, we have Delegate Coiner.
Good morning, Mr. Chair.
Good morning.
Mr. Chair and members of the subcommittee, I am before you with House Bill 277, and I do have an amendment in the nature of a substitute to bring before the committee.
Mr. Chairman, I've clicked off on that. We're going to have to wait just a moment to make sure it posts on LIS.
Just one moment.
I'm happy to explain the substitute while we're waiting for it to post, if that's helpful, Mr. Chair.
Yes, ma'am, please. Thank you.
So I am working with Senator Favola on a companion bill, and so the substitute that has been provided matches up. She's a little bit ahead of our bill over here in the House in the process, so it matches up with what she has gotten through in her committee with two changes. There are only two things in our House version that are different. In the previous version, for zoning ordinance purposes, we changed it from a maximum number of 8 residents to 50 square feet per bed per sleeping room. And I can explain that when we go through the full bill. And then the second thing that we did keep from our original bill version that she did not have in hers was in regards to the use of public funds being specifically used only for certified recovery residences.
Okay, we have a substitute. We have a motion to adopt the substitute.
Mr. Chairman, I don't see the substitute online. It's probably my looking in the wrong place. But I'll make a motion to accept the substitute, and would like a little bit of help to be able to see it.
All right, thank you, Delegate LaRock. We have a motion to accept the substitute. Do we have a second?
Second.
We have a second. All in favor say aye.
Aye.
Aye. All opposed? Okay, Delegate Coiner.
Thank you, Mr. Chair. Mr. Chairman and members of the subcommittee, House Bill 277 addresses a few items all within one bill, all related to recovery residences in the Commonwealth. It addresses publicly funded referrals to recovery residences, standards, zoning, as well as tenancy and occupancy exemptions for certified recovery residence operators. We know that COVID has exacerbated the addiction epidemic in Virginia, and we know that the need for recovery support is at an all-time high. What we have also seen as that has happened is that we are in need of being able to assure our communities, our neighbors who are in need of support in their recovery journey, that we as the Commonwealth are assuring that there are some minimal levels of care when your loved one gets referred for support in recovery residences. This bill establishes consumer confidence in Virginia's certified recovery residence network that provides services for thousands of Virginians with a substance use disorder while ensuring the health and safety of residents in the broader community and neighborhoods that they reside in as neighbors. All entities receiving state funding, including probation, pretrial, Department of Corrections and Treatment Facilities, would be referred to certified recovery residences as certified by the Department of Behavioral Health and Developmental Services. The bill also requires that every recovery resident shall disclose whether that residence is certified, and if so, whether the credentialing entity is the National Alliance for Recovery Residences or Oxford Houses, Inc. The bill clarifies and reinforces standing and well-established Federal Fair Housing Act and Virginia Fair Housing Law rulings that already protect recovery houses and entitle them to enjoy family status in neighborhoods zoned single-family residential. Zoning ordinances for all purposes shall consider a certified recovery residence, which a certifying entity verifies there's 50 square feet per bed per sleeping room as residential occupancy by a single family. What we heard from many of our communities is because we have not had a standard to guarantee a minimal level of quality, we saw pictures of homes that were chopping up bedrooms into much smaller amounts than this for places that were not certified and therefore didn't have a minimal standard. And it was deemed very unsafe for the individuals who are living in these situations. This bill further clarifies the relationship between a recovery residence operator and a resident, exempting both from the provisions of the Landlord-Tenant Act for specific items. Our recovery residence operators need the ability to immediately remove someone from a home if they begin using, because it is important that our recovery residences maintain their safety and well-being of the other residents, and the Virginia Landlord-Tenant Act would preclude them from being able to do that immediately. It also would allow residents who do have to be removed to be able to do so without fear of legal consequences from breaking a lease. So it's equally important for the tenant as well. Virginia's continued commitment to proven community-based recovery will increase our ability to effectively respond to the addiction epidemic, ensure better recovery outcomes, and save lives. I'd be happy to answer any questions. I do know there are folks here to speak to the bill.
I have a question, Mr. Chair.
I'm sorry, Delegate, we're going to take testimony, if that's okay first. And I do believe we've got several people in the queue to speak on this issue, both in person and virtually. And so because of that, there are a number of time constraints right now with several of the committee members. We are going to limit that testimony to 30 seconds. And I know that I was very polite early in the meeting, but we have to leave this at 30 seconds and no more. So first, let's, for the in-person testimony, is there anyone from, and we do have a number of representatives from one organization or another, several with one organization. And so is there anyone here from Oxford House? I think we have a Paul Stevens. And if we could limit testimony representing Oxford House to one individual, please. Thank you.
Yes, Mr. Chairperson. Good morning, Mr. Chairperson and members of the committee. My name is Paul Stevens. I have been a person in long-term recovery from opioid use disorder for 20 years. The original language of HB 277 would have changed existing law by arbitrarily removing Oxford House Incorporated as a credentialing entity and prohibiting self-run, self-supporting recovery homes by requiring staff for certification. We would like to sincerely thank Delegate Coyner for recognizing that these provisions would have drastically reduced the availability of much-needed recovery housing and would have had profound life-threatening negative consequences for Virginians who suffer from substance use disorder and their families. The new language of HB 277, here matching SB 622, its counterpart, reaffirms Oxford House Incorporated as a trusted credentialing entity and safeguards the future of individual self-run, self-supporting Oxford houses. On behalf of over the 250 professional allies, supporters, residents, family members, and landlords of Oxford House who expressed their opposition to HB 277 by public comment, email, and phone, I can say these changes mean they collectively withdraw their opposition to the bill. We would like to thank all of those who took the time to express to their legislatures how much they believe in Oxford House's strong standards. Oxford House Incorporated is the credentialing entity for individual certified Oxford houses, supports the current version of HB 277. It will accomplish its express intended goal of increased transparency and informed consent and will bring positive support and growth to all recovery residences. While it would, our only concern, while it would not apply to the individual Oxford houses, is with the legality of a section the bill does not share with SB 622, 372431.1, letter D, prohibiting healthcare providers and state agencies from referring individuals to substance use disorders.
Sir, I apologize, but you've gone over 30 seconds. Thank you very much. Okay, do we have Mr. Sangster? What, Delegate, I apologize, but we'll take questions and comments after. That's fine. Thank you.
Mr. Chairman and other delegates, my name is Bob Sangster. I'm a person in long-term recovery. I haven't had a drink or a mood-altering substance for more than 20 years. My family is in recovery. My son helps me with a group of recovery houses called the Frog Houses. We started that in 2006. We have a house manager that lives at each house. They have from 2 years in recovery to more than 30 years in recovery. I hate to say this, but I don't want to jinx it, but since our first men's house that opened in 2007, we've never had a resident die in one of our houses. I'm on the advisory board for the Rams in Recovery. I'm on the advisory board for the JHW Foundation, helping young people in recovery, and I'm on the board for the Farley Center Williams Reclase Foundation. The one point that I need to make is I could tell you about all the awards that we have received. My concern here is lines 57 through 60 of House Bill 277. And some questions to ask ourselves. Does a history of referrals with positive outcomes mean anything? Does anyone know more about referrals to recovery houses than those making those referrals? Treatment centers, IOPs, drug courts, community service boards, hospital detoxes, substance use counselors, etc. They're the ones that have the lived experience with their referrals. And they make their referrals based on the outcomes that they've gotten from the recovery houses that they have referred people to. I ask that these lines 57 through 60 be deleted from this proposal. Thank you.
Thank you, sir. Due to time constraints, I'm going to request that this bill go by for the day. We have a number of people that have other commitments, and we've got some other bills that I don't think will take as long as this one. And so, Delegate Coiner, I believe you're in agreement with that. And so, is there a motion to take this bill by for the day?
I have a motion.
So moved. Okay, we have a motion and a second. Do we have a second? Second. We have a second. Okay, thank you. That is a voice vote. Thank you, Delegate. All in favor, say aye. Yeah. Aye. All opposed? Thank you. Okay. Okay, Delegate Bennett Parker.
Thank you, Mr. Chairman. This is House Bill 465. It is a permissive bill that recognizes that increasing the supply of housing affordable to workers at all income levels is critical to Virginia's economic competitiveness and growth. My district, among others, has an affordable housing crisis. In order to afford an average one-bedroom apartment, someone earning the minimum wage would need to work 18 hours a day, 7 days a week, and they would not have any money left over for anything else. This bill grants certain localities, those that have an affordable dwelling unit ordinance, the permissive authority to require a contribution to the locality's affordable housing fund for new development, consistent with their local policies. The bill reflects a consensus recommendation of a stakeholder group in our community, which included developers, land use council, housing advocates, as well as representatives of special interests. It would add a tool to the toolbox to allow a locality to further its goal of maintaining a healthy stock of affordable housing. Thank you, Mr. Chairman.
Mr. Chairman?
Yes, Delegate Shin.
Mr. Chairman, I would like to move to lay HB 465 gently on the table, and I'd request a letter from the chair sending this bill to the Housing Commission to further study the ways to incorporate affordable units within private development and balance competing and complementary goals and needs of private development and the public sector.
Okay, thank you, Delegate Shin. We have a motion to lay the bill on the table. Do we have a second?
Second.
As she stated, with a letter.
Referring to housing. Second, as stated.
As stated, all in favor, say aye.
No, wait a minute.
I'm sorry, that is.
Yeah, let me find it, lay on the table, all right.
That is a recorded vote. Please vote.
Delegate Shen,
Aye.
Delegate Cordoza, are you recorded?
she's not taking, that's the problem here. Yeah, there you go. Oh, uh-oh.
Okay, we please clear the,
Okay, close.
we're voting on the wrong bill.
All right, so it's 648? No.
465.
4, all right.
So we have a motion and a second. House Bill 465.
And this is to lay on the table.
Lay on the table.
Yes, to lay this bill on the table.
Yes. with the
Please
letter.
vote.
Delegate Shen,
Aye.
Okay, the bill's laid on the table. Delegate Bennett Parker. Now we have House Bill 448. I'm sorry, 465. Yeah. No.
Which,
No, it's
yeah, we just did
it's
465.
we just did 465.
The one
So
that
it's
I messed up was 4. Is it beginning at what?
okay. All right. Thank you, Delegate Bennett Parker.
Okay.
Okay, Delegate Supamamran.
Thank you, Mr. Chair, members of the committee.
Thank you.
It's good to be here. The bill number here is HB 377. And I just want to explain the problem first to help you understand the text of this bill. Essentially, so as you know, localities give grants to nonprofits in the region, and these grants incentivize these nonprofits to do good work in the community and fill gaps. And the issue at hand here is whether they can give grants to religiously affiliated nonprofits. And so, some counties do allow this, some counties don't. But the Supreme Court in 2017 ruled pretty clearly that not giving grants to religiously affiliated 501c3s is unconstitutional under the First Amendment. But the issue here is that our code is not clear on that. And in fact, I think many lawyers that I've talked to in many counties, that, including mine, Loudoun County, interpret the Code of Virginia right now as being in conflict with that Supreme Court decision. And so this is essentially to clarify that and clarify what the law is and put the code in compliance with the Supreme Court decision. That decision was Trinity Lutheran Church of Columbia versus Comer from 2017. And so we're basically just clarifying to counties what the law is and allowing them to be able to interpret it more clearly. And there's also an amendment a couple of amendments I'd like to move as well.
Okay, please state the amendments.
So the first amendment is on line 22, or line 23. We changed the word from non-religious to secular, and I'll explain that amendment. Essentially, secular is better defined in court in case law, and so it'd be easier to interpret. And whereas non-religious, what's religious and what isn't is a little bit murkier. The second is line 23, 24, and 25. Just essentially restating and clarifying that the current obligations created by Virginia's accommodation statutes. Not biasing based on background or disabilities or anything like that, and also still protecting religiously affiliated organizations and their own houses of worship from their own beliefs. And so those are the two amendments, and I move them right now.
Okay, do we have a motion to adopt the amendments?
So moved.
We have a motion. Do we have a second?
Second.
All in favor say aye.
Aye.
All opposed? Okay. Do we have anyone to speak in favor of the bill in person?
Thank you. Good morning, Mr. Chair, members of the committee. Karen Addison with Troutman Pepper Strategies, representing Loudoun County. Thanks to the delegate for putting this in for the county. And as he mentioned, during the pandemic, we saw an increased need, and the county was able to come forward with grants or direct appropriations to nonprofit organizations who were providing human services to our residents. And we noticed that we sort of needed clarity on this issue, and this would also help with staff time to be able to directly appropriate these funds. And as the delegates explained, as long as these organizations are providing services to individuals without regard to their religious affiliations or beliefs. So this was put in at the request of the county, and we appreciate your support. And I have our deputy county attorney on Zoom to answer any questions for you.
Okay, thank you. You mentioned the deputy county attorney. Is that Ms. Sidnor? Sidnor?
Yes, sir.
Okay, yes, please go ahead.
Good morning. Thank you, Mr. Chairman. I will defer to our representative in the room, and again, thank the delegate for bringing the bill forward. And I understand you have time constraints, so I would just be available to answer any questions that committee members might have about this bill, but we do ask for and appreciate the support. Thank you.
Okay, thank you. Do we have any questions or comments from the committee? I believe we have Delegate Waxman. Do you, Delegate Waxman? I apologize, our virtual screens are not uploading correctly. Do we have any questions or comments from the committee?
We have more testimony.
Okay, yes, we have one more comment from the public.
Thank you, Mr. Chairman, members of the committee. Jeff Caruso with the Virginia Catholic Conference. We supported the original bill. We thank the patron for putting that in. We want to thank Loudoun County for their much appreciated interest in the issue. I'm not really here necessarily support or opposed to this version, but we do have concern about the second amendment that the patron offered, the one that references the public accommodation. My understanding of that is, so 2 years ago, the General Assembly passed non-discrimination provisions relating to employment and public accommodations and housing and some other areas. And as I understand it, this particular one references the public accommodations piece. And the concern would be that, first of all, it's unnecessary. It's a generally applicable provision in the code. And by putting that one provision in, our feeling is that puts singular emphasis on that one provision in the code without adding any number of other provisions that are also generally applicable. For example, Virginia also has a number of religious liberty laws. So if we're going to, put in something about, non-discrimination in public accommodations, we think that there are other equally applicable laws in Virginia. And perhaps more noteworthy, as was said when this bill was presented, the central issue here is Trinity Lutheran. And the compliance with that Supreme Court decision. So in our view, if anything is added, it should be provisions that echo Trinity Lutheran, and to say that faith-based agencies should be treated on equal footing with other nonprofits. So we did want to express concern about that amendment, and again thank the patron and express our willingness to work with the patron and all stakeholders to come up with something that would be agreeable to all. I know this is a bill that's very important for our Catholic Charities agencies.
All right, thank you, sir. And next, please.
Mr. Chairman, Josh Hetzer on behalf of the Family Foundation. I just want to echo the same comments from Mr. Caruso. Did have an opportunity to work with the patron on this bill. We generally think it's a good idea, and I think he described it absolutely perfectly about what it does. I haven't seen the new non-discrimination language that's put on it, but our concern is that anytime that's introduced in the context of religious entities in particular, it can create some conflicts. One that comes to mind is a situation that happened in Alaska having to do with shelters, with victims of domestic violence and housing men and women separately, and with some of the non-discrimination policies that can come into play that can conflict with the way that some religious charities would handle things. So we are concerned about that language, but the underlying bill we absolutely support as being consistent with what the Supreme Court has said. Thank you.
Okay, thank you.
Mr. Chair, if I might add.
Yes, sir, go ahead.
Could we ask perhaps counsel if he could, because the intent behind that is just to clarify, is just clarity. And so just, does this create any more obligations that don't already exist, or change obligations for religious affiliates or religious nonprofits compared to other nonprofits?
Okay, Mr. Sharp.
Mr. Chairman,
I'm sorry, go ahead. Yeah, sorry.
Mr. Chairman, given that the language says existing obligations, it shouldn't create any others that weren't already there as applicable to the situation as.
Thank you. And that was the intent, was not to create new obligations for these religious 501c3s, but rather just, again, clarity for the counties and the cities.
Okay, thank you. All right, do we have any further comments or questions from the committee? Okay, we have a motion. Please go ahead.
Thank you, Mr. Chair. Mr. Chair, I would move to report the bill as amended.
Okay,
Second.
we have a motion to report with a second. Please vote.
Delegate Shen.
Aye.
Okay, thank you, Delegate. The bill reports 8-0.
Thank you, Mr. Chair.
Thank you. Okay, just by a show of hands, we do have a couple of more bills, and just trying to get an idea from the members as far as timing. My schedule is pretty free for the next 30 minutes to an hour. How does it look for you all? 30 minutes? Yeah. 30 minutes? Okay. Okay, thank you. Delegate Bulova, and we apologize for you having to wait so long this morning.
Mr. Chair, I appreciate your fortitude, and in fact, I was able actually to go up and do my meeting and come back, so this all worked out really, really nicely.
Wonderful. We've had some technical issues and attendance issues today. So.
Anyways, but no, I appreciate it, Mr. Chairman and members of the subcommittee. This is House Bill 437, and I think as you all are very aware, state capital projects can have a pretty big impact on the surrounding communities. And so, that can include anything from traffic congestion to stormwater issues to light and noise issues. These are necessary facilities, right? And they're important facilities, but they can have an impact on the people who live around them. And so even though that the local government can't control these state projects, they're not subject to zoning ordinances, they're not subject to subdivision ordinances. The current code does recognize that these projects have impacts, and so any project involving new construction of over $500,000 has to go through a notification process to the locality. And if the locality wants, then it can actually request copies of the project plans. And so that makes a lot of sense. It gives the opportunity for the locality to go ahead and weigh in with regard to the plan's consistency with local ordinances or the comp plan. The locality doesn't have a veto, but it's very valuable information that the state agency can go ahead and take back to make sure that the project is a good neighbor. Mr. Chair, what this bill would do is allow the locality to request at least one public meeting as part of that process to help solicit input during the planning stage of the process. And so again, while we recognize that the community doesn't have any veto power, it is useful to be able to understand their concerns so that reasonable adjustments can be made and considered. And it's same reason that we require local governments to have public meetings, same reason that we have public meetings like this today. We had a case actually like this in our district recently. So it was a large DMV facility that was planned. Although it was late in the process, DMV actually ultimately agreed to hold a public meeting. And what was really cool about that is the public came out, they engaged, and they were actually able to make some meaningful changes. And so it would be very helpful to be able to exercise that option a little bit earlier in the process. And so, Mr. Chair, a lot of localities, they won't want to exercise this option. But again, some of these projects have real impacts. And so the ability to be able to ask a public agency to come out and at least do one public meeting to engage the community, I think is very reasonable in these cases. And that's all the bill does. So thank you, and I appreciate your consideration.
Okay, thank you. And we will take questions and comments from the committee after the public comments. And so do we have anyone here in favor of the bill? Yes, ma'am.
Mr. Chairman, members of the committee, Joanna Faust on behalf of Fairfax County. We'd like to thank Delegate Bulova for bringing this bill. I know the committee is pressed for time, so I'll just make 2 quick points. On behalf of the county, we work so closely with the state, so we would welcome any increased avenue for increased coordination or another option for increased coordination. That's always something that we value, understanding that we don't have the veto power, but just for this coordination. And secondly, on behalf of our Fairfax County citizens, our residents, this provides more transparency and input of what's going on in their communities, and also education so that they can answer their question or ask their questions and find out what's going on. So we would welcome that and support the bill. Thank you.
Okay, thank you. We have no one signed up to speak virtually. Is there anyone here to speak against the bill? Okay, any questions or comments from the committee members? We have Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, I have a motion.
We have a motion.
Thank you, Mr. Chair. Mr. Chair, I would move to report the bill.
We have a motion to report and a second. Please vote.
Delegate Shan?
Aye.
Okay, thank you, sir. The bill reports.
Thank you so much. I appreciate it.
All right, thank you. Okay, next we have Delegate Converse Fowler. Delegate Fowler, I believe you have House Bill 38 and House Bill 541. Which do you prefer to present first?
HB 338, is that okay,
Yeah.
Mr. Chair?
Yeah, please go ahead.
All right. Thank you, Mr. Chair. HB 38 prohibits any constitutional appointed deputy from serving in public office simultaneously. There are obvious reasons we would want to prevent this, including the enormous conflict of interest when voting on issues relating to your respective department, salary, policies, etc. Not to mention the amount of influence you would have in your workplace given your public office platform. I hope the subcommittee will report this bill in full committee. And thank you, Mr. Chair, and I can answer any questions that the committee may have.
Okay. Do we have anyone here in person to speak, excuse me, in favor of the bill? All right. Do we have anyone here in person to speak against the bill? And we do have one individual to speak virtually, but we'll wait until after the in-person testimony is completed. Thank you, sir.
Thank you, Mr. Chairman, members of the committee. Beck Stanley for the Virginia Agribusiness Council. We do oppose the bill. There's a stakeholder-driven process ongoing and a negotiation, and this bill is separate from that, so we would ask that you oppose. Thank you.
Thank you. Okay, we have one person signed up virtually to speak. Is Miss Elizabeth Hobbs on the phone?
Hi, Mr. Chairman, committee. I represent the Virginia Sheriff's Association. We are in opposition to this bill. We represent 118 out of 123 sheriffs across the state of Virginia, and we have 9,900 deputy sheriff members. We are opposed to this bill. Dual office requirements typically pertain to 2 elected positions. A deputy is an employee appointed at the will of the elected constitutional officer. The Virginia Constitution and the Virginia Supreme Court interpreting the Virginia Constitution has indicated that dual office holding provisions specifically do not apply to deputy sheriffs. This bill would deny deputy sheriffs the ability to help protect public safety by serving on local governing bodies. It would deny citizens the right to elect deputy sheriffs to serve in other capacities. It sets a dangerous precedent of disqualifying certain persons from holding elective office because of their employment. As mentioned by the delegate, local governments do not control salaries or employment practices of constitutional officers, so they do not make decisions that would impact the employment of the deputies of constitutional officers. This bill could lead to dangerous disenfranchisement of this class and other classes of citizens. Please oppose and vote no for House Bill 38.
Okay, thank you, Ms. Hobbs.
I apologize. I thought we were talking about the tree bill. I apologize. I withdraw my previous testimony. Sorry about that. Very embarrassing.
Thank you. Thank you.
Well, by the way this morning's been going, nothing surprises me. So.
Mr. Chair?
Okay. Yes, ma'am.
I just want to comment, Article 2 of the Constitution says on Section 3, under the General Assembly, nothing in this Constitution shall limit the power of the General Assembly to prevent conflicts of interest, dual office holding, or appointive office of the Commonwealth of only political subdivisions. That we do have authority to do this. It's just a matter of if we want to do it or not, and it does happen. I do understand there are localities that are smaller that may need to share resources and may need to share their positions, and that's allowable in the code. And if the will of the body is to go ahead and let appointees that are in chief deputy situations run city councils, then that's the decision of this body.
Okay.
Mr. Chair.
Thank you, Delegate. We'll now go to questions and comments from the committee. And I don't believe we have any, so do we have a motion?
Motion to report.
We have a motion to report. Do we have a second?
Second.
We have a motion to report with a second. Please vote. Oh, we have a substitute motion. Please state.
Move to lay it on the table.
We have a motion to lay the bill on the table. Do we have a second?
Second.
We have a second. Okay, we have a motion to lay the bill on the table with a second. Please vote.
Delegate Shen.
Aye.
Okay, Delegate, the bill is laid on the table. Okay, now we will go to House Bill 541.
Mr. Chair, I think, Delegate, could we pass that by for the day? I think Delegate Belova's bill may be more encompassing with this bill, and I think that it may need to just be rolled into his bill. I'm not sure, but it's not up today. Could we pass it by for the day, Mr. Chair?
Yes, ma'am. We have a request for the bill to go by for the day. Is there a motion? We have a motion and a second. All in favor say aye. This is a voice vote. All in favor say aye.
Aye.
Aye. All opposed? Okay. Thank you, Delegate Converse Fowler. All right. And you have House Bill 372.
Yes, thank you, Mr. Chair. Thank you. HB 372 is a bill that would prevent localities from imposing excessive restrictions relating to ages for Halloween trick-or-treating in a way that does not interfere with already established loitering and curfew provisions. In 2019, Chesapeake made national news for a law that charged children over the age of 14 with a Class 4 misdemeanor for trick-or-treating. This bill is only for Halloween and does not attempt to adjust set curfews enacted by localities. The aim of this bill is not to disrupt a city's curfew and only strives to address unreasonable restrictions. While Chesapeake changed their law, we would like to make sure that our Commonwealth's teens aren't charged with Class 4 misdemeanors simply for trying to enjoy the Halloween spirit, as there are other localities with similar ordinances in the books. Mr. Chair, I hope that this committee will support this bill. Thank you for your time.
All right, thank you. Do we have anyone to speak here in favor of the bill? All right, I don't think that we have, let me check. Okay, we have no one signed up virtually to speak on the bill. Do we have any questions or comments?
Quick question.
Yes,
For the
Delegate,
patron, just to clarify, in this bill where you talk about the timeframes between 6 p.m., between 10 p.m. and 6 a.m. So basically, we're saying that trick-or-treating until 10 o'clock is permissible, and then between, is that what we're saying?
Yes.
That's the general
Yes,
we're
just saying that the localities can't enforce any age restrictions. That's all.
Age restrictions. Okay, gotcha.
Age restrictions, yeah.
Okay, all right, cool beans. Thank you.
Mr. Chair, if I may.
Yes.
My daughter's 12. She looks like she's 16. She's taller than me. Her last year trick-or-treating, and it's a good thing for kids to be trick-or-treating and rather than out doing other things. And criminalizing that. And I think the pandemic, I heard lots of comments from parents reaching out about this and why do we even have a limit? Give them something to do. So I just wanted to reiterate where the bill came from. Thank you, Mr. Chair.
Thank you. I do have a question. So would this apply to all ages?
It would apply. The only thing in the bill that we changed is that you cannot impose restrictions relating to age on the activity commonly known as trick-or-treating.
Okay, can you give us just a brief history or background of restrictions on trick-or-treating and so forth? I'm not very familiar with that.
So as of right now, my locality says that my daughter can no longer trick-or-treat. So she will have to find other things to do with her friends when she's 13 on Halloween night, which usually is not the best scenario. Going to festivals and going to events would be the best option. This just says the locality can't restrict the ages. It has to let everyone participate. It's your choice. If you wanted to not hand out candy, you can turn off the lights. That's the custom tradition of that. But I know in neighborhoods that I live in my constituents, in the districts, there's a lot of conversation during the pandemic about why we wouldn't allow them because they need things to do. So, thank you, Mr. Chair.
Okay, so I'm trying to wrap my head around this. So right now, if you are 18, can any, unless if there is no restriction, I'm assuming that anybody can go trick-or-treating.
Well, according to, Mr. Chair, according to local ordinances, depending, it's restricted by age, and it could be enforced with misdemeanors, the way it's written for teenagers 14 and up.
Okay, Delegate Cordoza.
Question for the patron.
Yes.
Is there a safety issue reason? What would be a locality's reason for restricting the age of a trick-or-treat? Is it a safety issue? Is it just a health issue? Is it only pandemic related? What? If you can explain why they would have done that in the first place, I would appreciate that.
Mr. Chair.
Yes, go ahead.
It's been around since I was little. I think it's just a tradition to set the times and set okay, here's what we're doing for the kids. But I don't believe there's any recent history. It would be pretty far back to understand why. It's not in the code right now. It doesn't say anything about restrictions. We're just saying you can't have any restrictions on the ages. Families are going around together, Mr. Chair, as if I can explain the trick-or-treating that is usually going on.
Do we have any follow-up questions?
I have one.
Just 1 minute. I'm sorry, Chairman Hodges, please.
Thank you. So if a locality has a curfew provision ending at 10 p.m., this would allow trick-or-treating to go until 10 p.m.?
No, Mr. Chair. No, it wouldn't. It wouldn't mess with any loitering or curfew statutes at all. It only applies to related to the age on the activity commonly known as trick-or-treating in a manner that exceeds the loitering or curfew provisions generally established pursuant to this section.
Okay, and then just follow up, Mr. Chairman.
Yes.
So if 17-year-olds then would be, if there is a restriction now, you know, under 13 and under, this would now allow 17-year-olds to trick or treat, correct?
Yes, Mr. Chair, it would allow 17-year-olds to be trick-or-treating instead of doing whatever else they would be doing.
Okay, and I apologize, you may have stated this earlier, but did the locality request this?
No, it was parents. Mr. Chair, it was parents who requested it.
Okay, and I apologize, individual parents or parent?
Just Mr. Chair, I'm sorry. Constituents brought it up to me several times in the last 2 Halloweens during the pandemic.
Okay, is the locality aware of the legislation?
We did bring it to the localities. I don't think we got an opinion back. Did we? I don't. Chesapeake didn't have an opinion, didn't have a position. I don't think Virginia Beach did either.
They didn't have.
We did present them with a bill, and nobody seemed to have a position.
Okay, so there was no position for or against.
Not that we have, but we did send it, yes, and we followed up.
Okay, we have a question, Delegate Waxman.
Yeah, Mr. Chair, would this prevent a locality from, say, not allowing trick-or-treating because of something like a pandemic where they would be concerned about, you know, safety issues for the children?
Mr. Chair, it would not limit anything else, only that if they decided to do Halloween, they couldn't put an age restriction on it. That's all.
Mr. Chair?
Yes.
Question for the patron. If I'm, excuse me, if I'm understanding you correctly, the only thing that this bill does is allow children of any age, excuse me, of any age who are considered minors to trick or treat. So that could be a 17-year-old being a chaperone to their 8 or 9-year-old brother or sister. They would still be okay, and they could still participate in trick-or-treating, or it could be the 17-year-old or the 16-year-old participating in trick-or-treating themselves.
Mr. Chair, I would say yes. A lot of the time siblings go together, so that does make absolute sense. It just allows minors still, but just we're not going to cut them off. So my 13-year-old now, I don't have to worry. I wouldn't have to worry about what she's doing that night, running around with her friends. I know they're going to, when they come back with candy, that they've been out trick-or-treating, actually.
So it's just to the age, not anything else. And if there were a pandemic or some other restriction, that would, if they cancel trick-or-treating, it's canceled no matter what. Is that right?
Mr. Chair, yes, that's correct.
Okay, and I know, thank you. We've got a couple other questions, but I do have a question for staff. Statutorily, would the locality not have the authority to adopt their own curfew and loitering regulations and age restrictions as it would pertain to trick-or-treating?
Mr. Chairman, yes, that's the current state of law. This statute would then prevent localities from imposing those age restrictions.
Okay, and so under the current statute, though, the locality she's referring to, or any other locality, would be able to set no age restrictions on trick-or-treating?
That's correct.
Okay, thank you, and I've got a comment after the other questions from the committee members. Okay, Delegate Mullen.
Mr. Chair, I have a motion at the appropriate time.
Okay. Well, we've got just a couple of more questions. Okay, Delegate LaRock.
Thank you, Mr. Chairman. I think this is a question for council. Given the Dillon rule of statutory construction and my general understanding of it, local governments are not allowed to exceed provisions of state law. So would this be a situation where Dillon rule would already block a more restrictive set of ordinances that pertain to loitering?
You could always make that Dillon rule argument, Mr. Chair. I think the statute is broad enough that localities probably feel like they've got some flexibility currently to set age restrictions and that sort of thing, if that's what they desire to do.
Okay. I don't think we have any other questions or comments, but I do have one comment. So historically, Delegate, the way that this committee operates when dealing with localities is we would prefer to see some official endorsement from the locality of the legislation. I know you said that a group of parents had asked for this, but because of the issue that Delegate LaRock brought up with the Dillon rule, and then also because localities, according to staff, do have the authority to set those age restrictions, I would feel more comfortable supporting the bill with some sort of official resolution from the locality. So with that being said, I think there may be a motion.
Mr. Chair, may I comment?
Yes, go ahead.
I don't believe any Mr. Chair, I don't think any locality is going to come in and say, please restrict us. This would be the General Assembly saying, you know, we want children and minors to be able to have something to do on that night where all the younger children are having something to do. It's actually very positive in the community. So just wanted to mention. Thank you, Mr. Chair.
No, and thank you, Delegate. And I agree with you, but I think that in this situation, if the locality is receiving a tremendous amount of support for this, that their representatives would take that up. And it appears to be that they statutorily have the authority to adopt those restrictions. And so that's just my personal opinion. Okay, Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, I would move to report the bill.
Second.
Mr. Chair, I would entertain an alternate motion.
Okay, we have a motion and a second. We have a substitute motion to lay the bill on the table. Is there a second?
Second.
Okay, there is a substitute motion to lay the bill on the table with a second. Please vote.
Delegate Shen?
No.
Okay, I'll put you, vote you. Okay. 4-4.
Okay, no, it's 5-4. Okay, the bill's laid on the table, 5-4. Thank you, Delegate. Yeah. Okay, I believe that completes today's docket. And just one moment while we confirm that. Does that complete the docket, Mr. Clerk?
Well, let's check and say, Clark, what happened to that one, 596?
That was referred to general laws.
Oh, it was?
Yes.
I'm not there right now.
Okay, thank you. Okay, thank you. Committee is adjourned. We will meet next year. Just kidding.